Welcome back to another video, and today we're taking a look at a case of an ex-husband and wife. They're fighting over the equity in their previous home. They're both pointing fingers, and someone is doing someone very dirty, and we just don't know who it is. What do you guys think? Let's take a look.
Okay, looks like everyone's in. This is the matter of Peterson versus Peterson. Susan Danke is here on behalf of the plaintiff, James Fleming on behalf of the defendant, and both parties are also present. And Ms. Danke, I believe this is your motion.
It is not my motion, Your Honor. It's Mr. Fleming's motion.
Oh, I see that now. Pardon me. Go ahead, Mr. Fleming.
Thank you, Your Honor. Your Honor, this is an interesting situation here that really arises out of the parties trying to cooperate and communicate post-judgment because of their minor children. And the minor children, after the judgment of divorce, were no longer minors in college, and they needed to have their tuition paid. Like many parents do, they, in the past, had signed the student loan agreements. However, after the judgment of divorce, Mr. Peterson could no longer sign a student loan agreement because of his ratio of his outstanding debt, which included the mortgage or mortgages on the marital home. The judgment of divorce provides quite clearly that they were to split the equity in the marital home, the net equity. Ms. Peterson was granted any type of principal reduction that she made post-judgment. But it was quite clear, and it is quite clear, and it remains that the judgment of divorce provides that they are to split the equity. Getting back now to the situation with the children, the parties had to do something to allow Mr. Peterson to sign the student loan paperwork. They agreed that Ms. Peterson would refinance the home into her own name, which would free up the party, Mr. Peterson, to be able to sign the student loan papers. Ms. Peterson reassured Mr. Peterson many, many times that if you sign it, I'll still pay half of the equity that you are owed pursuant to the terms of the judgment of divorce. The judgment of divorce has not been amended, modified, or changed in any way whatsoever. As it remains today, she still owes him half of the equity. However, when they went to the bank required Mr. Peterson, when Ms. Peterson went to the bank to get financed, it required Ms. Peterson to obtain a quitclaim deed from Mr. Peterson. Mr. Peterson signed the deed, and I've attached that. The deed provides that there is zero consideration. The deed actually has the phrase "and for other consideration" crossed off. And I think that's very enlightening considering what has taken place here. That is Exhibit A, and you can see for valuable consideration in the amount of $0 given in hand, and then this is crossed off, and other good and valuable consideration. So by signing this deed, all Mr. Peterson is really doing is foregoing his security in the property. Doesn't mean he's giving up any claim to half of the equity. And I know we're going to also discuss the letter that's Exhibit B, and that's dated December 30th, 2016. And let me explain this. It says, to whom it may concern. This is a letter that the bank required, Ms. Peterson's letter, that the Ms. Peterson's bank, that they required. And it states, at this juncture in time, which makes it a very vague statement, I have signed a quitclaim deed relinquishing my interest in the property. So he's relinquishing his interest, but he's not relinquishing or changing the judgment of divorce to my ex-wife, satisfying any financial obligation. Now that's pretty vague. There will be no exchange of money for this transaction. Again, we go back to at this juncture of time. That just indicates that for this transaction, we are not doing any payment. We have come to terms to satisfy the divorce decree signed in July. That's a pretty vague statement. It doesn't say anything about relinquishing specifically anything, and there was no consideration for that whatsoever. The fact of the matter remains, Ms. Peterson sold the house and stopped communicating with Mr. Peterson, even though in July of 2019, she specifically told him not to worry about it, that she would pay him half of the equity. She's told other people, specifically the party's children, that she would pay their father his half of the equity. Now, if the court plans on holding an evidentiary hearing on this matter, our offer of proof is that we will have to subpoena the minor children. Mr. Peterson does not want to, but I told him we'll have to subpoena the minor children, have them testify that their mother said that she would continue to pay one half of the equity from the sale proceeds to their father. And that was part of the deal on why Mr. Peterson signed the student loan papers, because that was the only way he could. He did it for his children. And now it appears Ms. Peterson wants to put those children right in the middle of this, wants me to subpoena them, wants them to testify, and that's our offer of proof. Ms. Denke has brought up the parole evidence
So
rule.
let me stop you for a minute. Your offer of proof is that the children were present when these statements were made.
They heard Ms. Peterson say to them or to Mr. Peterson that she will still pay him. They might have had those conversations alone with her. I don't believe Mr. Peterson and Ms. Peterson were present when the children said that, but the children have heard Ms. Peterson say that. Shall I continue?
Sure.
So I can address what Ms. Denke brought up in her response to parole evidence rule. I can address the statute of frauds, but the fact remains here is those are not applicable. If you get down to it, I've addressed that. I did a reply to her answer, a response to her answer, because she brought up some points of law. And I think I set forth that pretty clear in my response. I hope the court had a chance to review that. But what it comes down here is the parties had an agreement. The agreement was the judgment of divorce. The parties had to prepare this paperwork in order for their children to go to college and for Mr. Peterson to get the loan. The plaintiff benefited in this matter because it allowed her to refinance the mortgage in her own name. The parties benefited because their kids could have their tuition paid for with the student loan. So the letter to the bank was only signed by the defendant for the bank. It didn't modify the judgment of divorce. What's fair and what's equitable here is, and what is, to do the right thing is to live up to the terms of the judgment of divorce. And the terms of the judgment of divorce provide that half the equity in the house should go to Mr. Peterson. Now that amount is approximately $50,000 according to Ms. Denke's statement that we have, and we haven't calculated off the principal reduction in the mortgage. Certainly we can do so based upon whatever this court decides. We're asking that the court follow the judgment of divorce and make the plaintiff live up to her end of the agreement. Anything else, the plaintiff, Ms. Peterson, becomes unjustly enriched to the tune of $50,000. Thank you.
Ms. Denke?
Thank you, Your Honor. Your Honor, I know the court has my answer. I want to focus primarily just on responding to some of the things that Mr. Fleming said in his response to my answer. We do not believe that this matter should go any further. We believe that the quitclaim deed and the letter that was written in December of 2016 relinquishing his interest in the property makes perfectly clear what's happened here. If the court disagrees, then I think you do have to have an evidentiary hearing regarding any verbal agreement that Mr. Fleming claims was made, because we absolutely dispute that. The fact that they're threatening to bring in the children, my client obviously is distressed at that threat, but is not going to bow to that blackmail. With respect to the response that was provided in paragraph 3, it says that the plaintiff is incorrect when stating that the home shall be rebuilt with the insurance proceeds and held by the parties as tenants in common. If the court has the judgment of divorce there, it specifically indicates in paragraph 28 that the marital home shall be rebuilt with the insurance proceeds and held by the parties as tenants in common. That's exactly what it says. So the insurance money was put back into the home. My client ended up having to serve as the general contractor for that project, ended up putting in additional money, about an additional $40,000 into that home. The judgment of divorce goes on to say, at any time during the 4-year period and subsequent to the 4-year period, the plaintiff has the option to retain the home. Should she do so, the home will be appraised at that time. She would be entitled to the principal reduction from the date of judgment until he's paid his equity, and that they would also deduct the 2 mortgage balances. She would receive the principal credit reduction as to each mortgage, and then he would get 50% of the remaining net equity. So she had 4 years to live in the home without having to pay Mr. Peterson anything or to take these mortgages off of his credit. He came to her asking to have her refinance early. She did not have to do that. That was not her plan. That was not her idea. She agreed to do that for him. He bought a home approximately 10 months later. He would not have qualified for buying that home if these mortgages were still on his credit. He also said he needed to do it so that he could co-sign a student loan for his daughter. As far as my client knows, he never did that. Her father ended up having to co-sign a loan for her. If the court were to determine that you were going to reopen this case in spite of the quitclaim deed and the letter, that would be the period of time at the point that she refinanced that we would be looking at the value to be divided. And it's my client's position, there is no equity to be divided. When you look at the value of the home at that time, and it had to be appraised in order to be refinanced, you look at the monies that were paid on the principal mortgage reduction, the outstanding balances of approximately $182,000, and the $42,000 that she invested back into the home so that it actually appraised at that value, he actually ends up owing her $2,000. So it's her position. She didn't owe him anything. But when you look at the judgment of divorce, it says upon payment of his equity, he will sign a quitclaim deed relinquishing his interest in the property. When he signed that quitclaim deed, he did not get any equity. In fact, he signed something saying he was waiving any right to his equity. Even if the court agreed with Mr. Fleming that, he was going to get his equity when their daughter graduated, she graduated in June of 2018. The home was not listed for sale until a year later. Mr. Peterson did not come back looking for his equity when his daughter graduated. He came back looking for his equity when he got caught out taking large sums of money from his mother's bank account and had to pay her back. The motion suggests that my client had borrowed money from Mr. Peterson's mother and didn't pay it back, so he had to do that. That also is not true. Mr. Peterson borrowed that money from his mother and claimed that Mrs. Peterson was going to pay it back. And when his mother called Ms. Peterson, that was the first she had heard of such a loan. And in fact, there was no intention to pay back something that she had never committed to. They indicate in paragraph 6 of their response to my answer that she could not refinance the mortgages into her own name due to her poor credit history. But obviously, that's the whole crux of this, is that she did refinance them 2 years early. In fact, she pulled $28,000 out at that time to pay off other debt that she had, because she had, in the course of the divorce, assumed her daughter's student loans, her student loans, and Mr. Peterson's student loan, which had been consolidated all into one loan. The response goes on to say that my client clearly and unequivocally indicated to the defendant that the equity would be split. That did not happen. In fact, she believes he's not entitled to any equity because of the amount that she had put into the house and paying down the mortgages and the balance that was still owing. If, as he indicates in paragraph 13, she promised she would list the house for sale after their daughter graduated and pay that equity at that time, why was there no request for equity or no request or request for a court order to require the house to be sold in 2018? My client didn't list the house for sale until she had a new job and was moving out of the area. It is true that he tried to confront her in July of 2019 at the Clark Lake Beach and Boat Club. My client did not at that point agree that when the house was sold, she would pay him part of his equity. She didn't want to get into an argument with him at that time. She thought this whole thing had been resolved in 2016. She told him that it was not the place to discuss it and immediately tried to distance herself from him. There was a long history of domestic violence in this case. And frankly, she's terrified when she's confronting him, or he's confronting her, I should say, and angry about something. She did not change her phone number and not inform anyone of where she lived, as alleged in paragraph 19. She changed her phone number when she changed jobs, and her phone was connected to her job. So her phone number changed with a new work phone. She certainly did not provide Mr. Peterson with her address, again, because of the history of domestic violence. So she has no desire for him to know where she's living. But that's not that happened at a very different time, and the phone changing happened at a very different time than the summer of 2019. And that's why she contacted Mr. Hotchkiss with respect to the sale of the house. And now he was claiming he was entitled to some equity. And she wanted to make sure that, in fact, that was not the situation, that she had, in fact, done everything she needed to do with the quitclaim deed, with the separate letter making clear he was waiving his interest in the property, to satisfy the terms of the judgment of divorce. So at this point, I would ask that the court deny the motion in its entirety and award my client attorney fees, given the fact that he has signed the quitclaim deed and the letter waiving his right to any reimbursement. If the court is inclined to consider this matter further, I think you have to have an evidentiary hearing to address these oral agreements that Mr. Fleming and Mr. Peterson are claiming exist, and my client is denying. Thank you.
Anything further, Mr. Fleming?
Just, it's quite clear that there are many facts in dispute, and we do dispute what Ms. Denke just said regarding most of what she said. And with the court, if the court wants to hear more facts, then we obviously need an evidentiary hearing. I would agree with Ms. Denke on that. If the court can rule as a matter of law based upon the judgment of divorce, it's quite clear that that has not been amended, and the plaintiff, Ms. Peterson, did not pay him to share the equity, which also provides nothing about insurance proceeds or anything else of that matter. That issue of saying, I want credit for these, or for the extra $42,000 that I put into it, never came up in any of these, in the judgment of divorce. It didn't come up afterwards. And now she's making this argument that she's entitled to her $42,000 back that she had allegedly put into the house. We've never seen any proof on that. I highly doubt there was very much in principal reduction. She netted $100,000 out of the sale of this house, and she kept it all. And that is totally contrary to the judgment of divorce and what the parties decided to do to try to get their student loan. So Mr. Peterson could get the student loan for his child, their child. Thank you.
So, Mr. Fleming, I'm looking at your Exhibit B. I mean, the quitclaim deed doesn't really say anything other than I'm conveying my interest for no consideration. The letter, Exhibit B, says I've signed a quitclaim deed relinquishing my interest in the property, satisfying any financial obligation. There will be no exchange of money for this transaction. That sounds awfully clear that we've come to terms that satisfy the divorce decree. That all sounds to me like that's the end of whatever obligations relating to the home were created by the divorce decree. How does it not do that?
Well, it's not signed by Ms. Peterson. It's not in the form of an agreement like that. And the background with all this is that this was done in order for Mr. Peterson to get that student loan, and the parties had a side agreement. And the side agreement was, if you do this, I'll refinance the house. That's Ms. Peterson talking. I'll refinance the house. And Mr. Peterson is then saying, I'll get the student loan for our child. Ms. Peterson then says, I will still pay you half of your equity in the house. And that is what she is saying right there. Now, if you look at this as a whole, that's an oral contract that she made to pay. Now, some of the, is this part of that agreement to do that? No, this was an agreement to put this forth before the bank that both parties were part of. Both parties said to the bank, we're done with any financial transactions and obligations. And believe me, this letter was Ms. Peterson's idea. Both parties, I guess Mr. Peterson by signing it, Ms. Peterson by having Mr. Peterson draft this letter, sign this letter, and then present it to the bank, her bank, to refinance. We're both part of this in the sense that this is what they needed to give to the bank. This is what the bank understood that the bank wanted, and that's why they did it. The purpose wasn't to do what Mr. Peterson said in here. The purpose was to get the student loan. So if you look at separately, what Ms. Peterson said was, I will still pay you the money. I will pay you the money. And that's where we will bring in witnesses to testify to that, where after Mr. Peterson signed this, at the time Mr. Peterson signed this, the testimony will be that Ms. Peterson still agreed to pay him the money. So that's a total separate, subsequent type of contract. And that's why this, and I presented this to the court because I wanted the court to have this information, so it could have a fair understanding of everything that had transpired between the parties. So this in and of itself doesn't fulfill that obligation, because Ms. Peterson still made the promise to pay him half the equity in that house.
All right, I think I am going to have to receive some testimony. Before any hearing, I'm going to want each of you to submit, Mr. Fleming, you address at great length in your reply the parole evidence rule as it pertains to attempts to vary a written agreement. What you didn't address is the parole evidence rule as it pertains to interests in real estate. I want you to develop that, and Ms. Danke as well. I'm not sure whether which part of the parole evidence rule applies here. We also have the parole evidence rule that pertains to promises to pay money in excess of a certain amount. I think all of that needs to be fleshed out. I want to see all of that in your pre-hearing briefs. I will get with Dawn to give you a hearing date at some point in the future with sufficient time for you to get some briefs done and get them submitted in advance. Okay?
Yes, sir.
Very good.
Thank you,
All
Judge.
right, thank you.
Thank you.
And we're all